I was standing in my driveway on a Tuesday morning in Asheville, North Carolina, when I saw the certified letter sticking out of my mailbox. And something about that thick envelope told me my peaceful life was about to get complicated. My name is Xavier, and I had moved to this beautiful property in the Blue Ridge Mountains 6 months ago. The house sat at the end of a private road that I owned, a half-mile stretch of asphalt that wound through the trees from the main county road to my front door. The deed was clear, the survey was clear, and my property taxes reflected ownership of that road. It was mine, plain and simple. I tore open the envelope and started reading. The letterhead said Mountain View Estates Homeowners Association, and my stomach immediately dropped. I had specifically bought this property because it was not part of any HOA. I had checked 3 times with my real estate agent before making an offer. Dear Mr. Xavier, the letter began in that passive-aggressive tone that HOAs seem to specialize in. It has come to our attention that you have failed to pay your share of the street maintenance fees for Clearwater Drive. According to our records, you are now 6 months delinquent on these payments, totaling $3,450. Please remit payment within 14 days or face legal action and a lien on your property. I read the letter twice, then a third time. Clearwater Drive was the name of my private road, the road I owned, the road that was on my property deed. The road I had just paid $2,000 to have sealed and repaired last month. I grabbed my property documents from my home office and walked back outside, staring at the letter like it might suddenly start making sense. It didn't. I pulled out my phone and called the number at the bottom of the page. A woman answered on the second ring. Mountain View Estates, HOA, this is Deborah speaking. Hi, my name is Xavier. I just received a letter about street maintenance fees for Clearwater Drive. Yes, Mr. Xavier. We've been trying to reach you for months now. Your account is seriously past due. There's been a mistake, I said, keeping my voice calm. Clearwater Drive is my private road. It's on my property. I'm not part of your HOA. There was a long pause. Sir, Clearwater Drive is listed as one of the maintained streets within Mountain View Estates. All property owners along maintained streets must pay their proportional share of maintenance costs. I'm not along the street, I explained. I own the entire street. From the entrance at the county road to my house. The whole thing. It's been part of my property since 1973. Another pause. That's not what our records show. I'm going to have to transfer you to our board president, Patricia. The hold music was some tinny version of classical music that made my teeth hurt. After about 3 minutes, a new voice came on the line. This one was sharp and nasal, with that particular tone of authority that some people wear like armor. This is Patricia Harrington. I understand you're calling about your delinquent street fees. Miss Harrington, I'm calling because there's been an error. Clearwater Drive is my private property. I own it. I'm not part of the Mountain View Estates HOA, and I don't owe any maintenance fees. Mr. Xavier, I have the HOA map right in front of me, and Clearwater Drive is clearly marked as an HOA-maintained street. Now, I understand you may not like paying these fees, but all homeowners must contribute their fair share. I'm not a homeowner in your association, I said, my patience starting to fray. My property is not part of any HOA. I specifically bought it because it wasn't. Well, that may be what your realtor told you, but the facts speak for themselves. You live on an HOA street, which means you're subject to HOA fees. It's really very simple. It's simple, all right. I own the road. It's on my deed. I paid to have it maintained last month. If anyone owes anyone money here, you owe me for the years you've been using my road as an access point. I heard Patricia take a sharp breath. Young man, I don't appreciate your tone. The HOA has maintained Clearwater Drive for 15 years. We've paid for grading, seal coating, and snow removal. If you own this road as you claim, then you owe us reimbursement for all that work. You maintained my road without my permission, and now you want me to pay you for it. I couldn't believe what I was hearing. That's not how property rights work. Mr. Xavier, I suggest you consult with an attorney because you clearly don't understand how HOA regulations function. You have 14 days to pay or we will file a lien. Good day. She hung up. I stood there in my driveway staring at my phone in disbelief. This couldn't be real. This couldn't actually be happening. I went back inside and spent the next 2 hours going through every document related to my property purchase. The deed clearly showed Clearwater Drive as part of my parcel. The survey showed it. The title insurance showed it. There was not a single mention of any HOA anywhere in my closing documents. I called my real estate agent, Rebecca, who had helped me buy the place. Brandon, hi. How's the house? The house is great, but I've got a problem. Did you know about a Mountain View Estates HOA? No. There's no HOA on your property. That was one of your requirements, remember? We checked specifically. Well, apparently there's an HOA that thinks I'm part of their association, and they're trying to charge me $3,000 for maintaining my private road. Rebecca was quiet for a moment. That's crazy. Your property is specifically excluded from the Mountain View development. It predates the whole subdivision. The developer actually bought all the land around you but couldn't get your property included because the previous owner wouldn't sell. Can you send me documentation of that? Absolutely. I'll email you everything I have. Brandon, don't pay them anything. They have no claim on your property. After I hung up with Rebecca, I did what I probably should have done first. I called a lawyer. My friend from college, Derek, practiced real estate law in Charlotte, and while that was a few hours away, I trusted his advice. They're trying to charge you for maintaining your own road, Derek asked after I explained the situation. That's exactly what they're doing. That's ballsy. Okay, first thing, don't communicate with them anymore except in writing. Second, send them a cease and desist letter. I can draft one for you if you want, but the basic message is that they need to stop claiming ownership or authority over your property immediately, and they definitely need to stop sending you bills. What if they file a lien anyway? Then we go to court and get it removed and probably sue them for slander of title. But let's hope it doesn't come to that. Send me all your property documents and the letter they sent you. I'll put together a response that should make them back off. I spent the rest of the day scanning documents and emailing them to Derek. By that evening, I had a comprehensive cease and desist letter ready to send via certified mail. It laid out very clearly that Clearwater Drive was my private property, that I had never been part of the Mountain View Estates HOA, and that any attempt to file a lien would result in immediate legal action. I sent the letter the next morning. Then I waited. 3 days later, I got a response. Not from Patricia, but from an attorney representing the HOA. The letter was even more aggressive than the first one. Dear Mr. Xavier, our client, the Mountain View Estates HOA, disputes your claim to Clearwater Drive. While you may own property at the end of this street, the street itself has been maintained by the HOA for 15 years, establishing implied easement and maintenance responsibility. Furthermore, several HOA members use Clearwater Drive to access hiking trails in the area, which creates a public access right. Failure to pay the outstanding fees will result in legal action. I called Derek immediately. They're claiming implied easement, he said. That's not going to work. Implied easement requires necessity, and there are other ways to access those trails. Plus, 15 years isn't long enough to establish prescriptive easement in North Carolina. That takes 20 years of continuous, open, and notorious use. So what do? We wait for them to file a lien, then we sue. Or we could sue first for declaratory judgment. That would settle the question of ownership definitively. How much would that cost? A few $1,000s, probably. But if we win, which we will, you can likely recover your legal fees from the HOA. Let's do it. I'm not letting these people walk all over me. Derek filed the lawsuit the following week. We sued for declaratory judgment, asking the court to confirm that I owned Clearwater Drive and that the HOA had no authority over my property. We also asked for our legal fees and a permanent injunction preventing the HOA from claiming any authority over my land. The HOA responded by filing their lien anyway. They actually went to the county courthouse and filed a document claiming I owed them money, which attached to my property and showed up in public records. Derek said it was a strategic mistake on their part because it gave us additional claims for slander of title and wrongful lien. That's when things started to get weird. I was working from home on a Thursday morning, about 2 weeks after the lawsuit was filed, when I heard vehicles coming up my road. I looked out the window and saw a pickup truck and a small excavator on a trailer. The truck had Mountain View Estates HOA painted on the side. I went outside just as 3 men were starting to unload the excavator. "Hey," I called out. "What are you doing?" One of the men, a heavy guy with a gray beard, walked over. "We're here to do some drainage work on the road. HOA contracted us. This is my private road. The HOA has no authority here. You need to leave." The man looked uncomfortable. "Look, buddy, we just go where we're told. We got a work order from the HOA to fix some drainage issues." "I don't care what your work order says. This is my property and you're trespassing. If you start work, I'm calling the police." The man pulled out his phone and called someone. After a brief conversation, he handed the phone to me. "She wants to talk to you." It was Patricia. "Mr. Xavier, the HOA is exercising its maintenance rights over Clearwater Drive. We've identified several drainage problems that need immediate attention." "Get off my property," I said. "Right now. Take your crew and your equipment and leave, or I'm calling the sheriff. If you interfere with HOA maintenance operations, we'll have you arrested for obstruction. I'm the property owner. You can't arrest me for removing trespassers from my own land." I hung up and handed the phone back to the worker. "You need to leave. Now." The 3 men looked at each other, then started loading their equipment back onto the trailer. I stood there watching until they drove away, then I called Derek. "They actually showed up with construction equipment?" he asked. "Yep. I sent them away, but I'm worried they're going to try again. Get cameras. Document everything. And I'm going to file for an emergency restraining order to keep them off your property while the case is pending." I spent that afternoon installing security cameras at the entrance to my road and around my house. Then I put up "Private property, no trespassing" signs at the entrance to Clearwater Drive. The restraining order was granted 3 days later. The judge issued a temporary order preventing the HOA from entering my property or conducting any work on Clearwater Drive pending the outcome of the lawsuit. Patricia was not happy. I got an email from her later that day that was so full of legal threats and personal insults that Derek said it actually helped our case by showing the HOA's hostile intent. But the restraining order didn't stop the harassment. It just changed form. I started getting letters from the HOA about supposed violations. My grass was too long, according to one letter, even though I lived on 5 acres of mostly forested land with a small lawn that I mowed regularly. Another letter complained that I had a derelict vehicle on my property, referring to my vintage 1967 Mustang that I was restoring in my garage. A third letter claimed I was running a business from my home in violation of HOA rules. I forwarded all of these to Derek, who added them to our lawsuit as evidence of harassment. "They're trying to make your life miserable so you'll drop the suit," he explained. "It's a common tactic, but it's actually going to backfire on them. The judge is going to see this as retaliation." The preliminary hearing was set for 6 weeks after we filed. In the meantime, I tried to live my life normally, but it was hard. Every time I heard a car coming up my road, I tensed up, wondering if it was the HOA trying something new. The worst incident happened 3 weeks before the hearing. I came home from grocery shopping to find orange construction fencing across the entrance to my road, with a sign that said "Road closed for emergency repairs, Mountain View Estates, HOA." I was blocked from my own property. I got out of my car and pulled the fencing aside, then drove through. When I got to my house, I called the county sheriff's office. A deputy named Officer Martinez showed up about 20 minutes later. I explained the situation, showed him the restraining order, and asked him to document what had happened. "This is getting out of hand," he said after looking at all my paperwork. "You want to press charges for trespassing? Will that help?" "It might. At minimum, it creates a paper trail, and it might convince these HOA people to back off." I filed the complaint, and the sheriff's office sent a deputy to talk to Patricia. According to the report I got later, she claimed the HOA had a right to maintain the road and control access for safety reasons. The deputy explained that she was violating a court order, and further violations could result in criminal charges. The harassment stopped after that, at least temporarily. I got a couple more nasty letters, but no one showed up on my property. Finally, the hearing arrived. Derek drove up from Charlotte the night before, and we met at a coffee shop in downtown Asheville to go over our strategy. "This should be straightforward," he said. "We have your deed, the survey, the title insurance, and statements from the previous property owner confirming that Clearwater Drive has always been private property. They have nothing but their own internal records, which don't trump legal documents. What about their claim that people have been using the road to access trails? Permissive use doesn't create an easement. You can allow people to use your property without giving up ownership rights, and there's no evidence that any use was adverse or without your permission." The hearing was at the Buncombe County Courthouse at 9 in the morning. I wore a suit, which felt strange since I usually worked from home in jeans and a t-shirt. Derek looked comfortable in his lawyer uniform, carrying a briefcase full of documents. The courtroom was smaller than I expected, with wood paneling and fluorescent lights. Patricia was already there with the HOA's lawyer, a thin man in his 50s named Richard Thornton. Patricia wore a purple blazer and had her blonde hair pulled back in a tight bun. She looked at me with obvious disdain when I walked in. Judge Ellen Morrison presided. She was in her 60s with gray hair and a no-nonsense demeanor. After we were all seated, she reviewed the case file briefly, then looked up. "This is a hearing on plaintiff's motion for declaratory judgment and injunctive relief regarding property located at 47 Clearwater Drive. Mr. Patterson, you're representing the plaintiff." Derek stood. "Yes, Your Honor. Derek Patterson for Brandon Xavier." "And Mr. Thornton for the HOA." "That's correct, Your Honor." "All right. Mr. Patterson, this is your motion. Make your case." Derek walked through our evidence methodically. He submitted the deed showing that I owned Clearwater Drive as part of my property. He submitted the survey confirming the boundaries. He submitted title insurance documents. He submitted affidavits from the previous property owner and from Rebecca, my real estate agent. Your Honor, the evidence is overwhelming that Mr. Xavier owns Clearwater Drive outright as private property. This has been the case since the land was first subdivided in 1973. The Mountain View Estates development occurred in 2008, 25 years after my client's property was established. The HOA has no legitimate claim to this road. Judge Morrison looked at the HOA's attorney. Mr. Thornton, what's your response? Thornton stood and approached the bench with his own stack of papers. Your Honor, while the plaintiff may technically own the underlying land, the HOA has maintained this road for 15 years. We've paid for grading, seal coating, snow removal, and other maintenance. This creates an equitable claim for reimbursement at minimum and possibly establishes an implied easement for continued maintenance. An implied easement requires necessity, Mr. Thornton. Is this road necessary for the HOA to perform its functions? It's used by multiple HOA members to access recreational facilities, Your Honor. But is it necessary? Are there alternative routes? Thornton hesitated. There are alternatives, but this is the most convenient route. Convenience doesn't create necessity. What about prescriptive easement? You mentioned 15 years of use. We believe the continuous maintenance establishes a claim. North Carolina requires 20 years for prescriptive easement, Mr. Thornton. You're 5 years short even if you could prove all the other elements, which seems unlikely given that the plaintiff owns the road outright, and any use would have been permissive rather than adverse. Judge Morrison flipped through the documents again. Mr. Thornton, I'm going to be frank with you. Your client has filed a lien against property they don't own based on fees they have no right to charge. They've repeatedly trespassed despite a restraining order. They've sent harassing letters making baseless claims. This looks less like a good-faith property dispute and more like intentional harassment. Your Honor, my client genuinely believes they have maintenance responsibilities for this road. Based on what? Their own internal map that contradicts the legal deed. That's not reasonable, Mr. Thornton. The judge looked at some more papers, then made some notes. After what felt like forever, she looked up. Here's my ruling. The evidence clearly shows that Brandon Xavier owns Clearwater Drive as private property. The Mountain View Estates, HOA, has no claim to this property and no authority to charge maintenance fees or conduct any work on this road. The lien filed by the HOA is void and will be removed from county records immediately. The HOA is permanently enjoined from claiming any authority over Clearwater Drive or entering the property without Mr. Xavier's explicit permission. Furthermore, I'm ordering the HOA to pay Mr. Xavier's reasonable legal fees, which Mr. Patterson can submit within 30 days. Is all of that clear? Yes, Your Honor, Derek said. Thornton looked like he'd been slapped. Your Honor, we'd like to request time to appeal. You can appeal if you want, Mr. Thornton, but I'm going to advise your client that continuing this baseless claim could result in sanctions. This case was frivolous from the start, and only the fact that it's being resolved at the preliminary stage is saving the HOA from more serious consequences. We walked out of the courthouse into bright September sunshine. Derek was grinning. That went better than I expected. Judge Morrison doesn't mess around, so it's over. Unless they appeal, which would be stupid. But you never know. Give it 30 days, and if they don't file anything, you're in the clear. I paid Derek his fee, plus a bonus for driving up from Charlotte multiple times. He submitted our legal costs to the court, which came to about $4,500. The judge approved the full amount, and the HOA had to cut me a check. That should have been the end of it. The judge had ruled, the lien was removed, and I was owed money. But Patricia apparently didn't believe in accepting defeat gracefully. 2 weeks after the hearing, I was working in my home office when I heard vehicles on my road again. I checked my security cameras and saw 2 pickup trucks with Mountain View Estates, HOA painted on the sides, along with what looked like a mobile home being towed by a large truck. I grabbed my phone and went outside. The convoy had stopped about halfway up my road where it widened into a small clearing. Men were already unhitching the mobile home. "What the hell is going on?" I demanded. One of the men, a young guy with a clipboard, looked up. "We're setting up a maintenance shed for HOA equipment. This is the designated spot according to our site plan. This is my private property. You're trespassing." "Madam said we had right of way," the guy said, looking uncertain now. "You don't. There's a court order saying the HOA has no authority over this road. Pack up your stuff and leave, or I'm calling the cops." The guy called someone, probably Patricia. After a brief conversation, he looked at me. "She says we're allowed to be here." I pulled up the county sheriff's number on my phone. "I'm calling right now. You have 5 minutes to start packing up, or you're going to be explaining this to a deputy." That got them moving. They started hitching the mobile home back to the truck. I stayed there watching until they drove away, taking pictures and video the whole time. Then I called Derek. "She's violating the permanent injunction," he said after I explained what happened. "That's contempt of court. We can file a motion to hold her in contempt, which could result in fines or even jail time. Let's do it." Derek filed the motion that afternoon. The court scheduled an emergency hearing for 3 days later. This time, Patricia had to appear personally to explain herself. The contempt hearing was in the same courtroom with the same judge. Patricia arrived wearing another business suit, this time in navy blue, and she looked decidedly less confident than at the first hearing. Judge Morrison looked stern as she reviewed the file. "Miss Harrington, I issued a permanent injunction prohibiting the HOA from entering Mr. Xavier's property. Just 2 weeks later, you sent workers and equipment onto that property. What part of my order did you not understand?" Patricia stood. "Your Honor, we were simply trying to establish maintenance facilities that would benefit all residents in the area." "Miss Harrington, this isn't complicated. You don't own the road. You have no easement over the road. You have no right to be on that property for any reason without Mr. Xavier's permission. My order could not have been clearer. Your Honor, the HOA has been maintaining that road for 15 years. We have equipment, we have procedures. We need somewhere to store materials." "Then store them on property you actually own, Miss Harrington. This is a serious violation of a court order. I could hold you in contempt right now." Patricia went pale. Her lawyer, Thornton, stood up. "Your Honor, if I may, my client may have misunderstood the scope of the injunction." "I don't see how. The injunction says the HOA cannot enter the property. That's not ambiguous. Miss Harrington, did you personally authorize workers to enter Mr. Xavier's property after my order was issued?" "I believed we had a right to maintain access for emergency purposes," Patricia said. "Emergency purposes? You were installing a storage shed. That's not an emergency." Judge Morrison made some notes. "Here's what's going to happen. I'm finding the Mountain View Estates HOA in contempt of court for violating my injunction. The HOA is fined $5,000 payable to the court. Additionally, I'm ordering the HOA to pay Mr. Xavier an additional $3,000 in damages for his time and trouble dealing with this violation. Miss Harrington, I'm holding you personally responsible for ensuring compliance with my order. If the HOA or anyone acting on their behalf enters Mr. Xavier's property again without his express permission, I will hold you personally in contempt, and you will face sanctions that could include jail time. Am I making myself clear? Yes, Your Honor, Patricia said quietly. Good. This hearing is adjourned. I walked out of court feeling vindicated but also exhausted. This whole situation had consumed months of my life and thousands of dollars in legal fees, even though I was being reimbursed. All because an HOA decided they had authority over property they didn't own. Derek clapped me on the shoulder. That should be the end of it. Patricia looked scared, and she should be. Nobody wants to be held in contempt personally. Judge Morrison doesn't make idle threats. I hope you're right. For a few weeks, everything was quiet. I got a check from the HOA for the $8,500 they owed me for legal fees and contempt damages. The lien was removed from my property records. My security cameras showed no unusual activity. Then I started noticing something odd. Cars would drive slowly past the entrance to my road, sometimes stopping to take pictures. I didn't think much of it at first. The Blue Ridge Mountains attract tourists, and people often stop to take photos of the scenery. But after it happened several times, always with the same silver sedan, I started to get suspicious. I reviewed my security footage and got a clear shot of the license plate. Then I called Officer Martinez, the deputy who had helped me before. I can run the plate, he said. But unless they're doing something illegal, there's not much we can do about people taking pictures from a public road. I know. I just want to know who it is. Martinez called me back an hour later. The car is registered to a Patricia Harrington at an address in Weaverville. Of course it was. Patricia was surveilling my property. But why? I got my answer 2 weeks later when I received yet another letter from the HOA. This one claimed that I was operating a business from my property in violation of county zoning ordinances, and the HOA was filing a complaint with the county. I worked from home as a software developer, but that was perfectly legal in residential zones. Lots of people worked from home. But apparently Patricia had seen me receiving some equipment deliveries and decided that constituted operating a business. I called the county planning office to get ahead of the complaint. A friendly staff member named Jennifer looked up my property records and zoned regulations. You're zoned residential, but home occupations are specifically permitted as long as you're not seeing clients at the property or generating significant traffic. Working from home as a software developer is completely fine. So if someone filed a complaint, we'd investigate, but based on what you're describing, we'd find no violation. Do you want to file a preemptive statement explaining your situation? Yes, please. I submitted a detailed explanation of my work setup, emphasizing that I worked alone from home, didn't see clients in person, and generated no traffic beyond normal residential activity. When the HOA's complaint came in 3 days later, the county planning office reviewed it and dismissed it immediately. But Patricia wasn't done. Over the next month, I received complaints about noise violations, outdoor storage violations, and even a claim that I was keeping livestock illegally. All of them were false. All of them were investigated by various county departments. All of them were dismissed. Derek advised me to document everything and consider filing a harassment lawsuit. You've got a clear pattern of behavior here. Patricia is retaliating against you for winning the property dispute. That's actionable. I was tired of lawsuits, but I was also tired of dealing with false complaints every week. We filed a civil harassment suit against Patricia personally and against the HOA, seeking damages and a restraining order. The lawsuit got the attention of the local newspaper. A reporter named Sarah Mitchell called me to ask about the case. I've heard stories about aggressive HOAs, she said, but this sounds extreme. Would you be willing to talk about what you've been through? I was hesitant at first, but Derek said publicity might actually help. Sometimes sunlight is the best disinfectant. If people know what's happening, the HOA board might pressure Patricia to back off. I agreed to an interview. Sarah came to my house, and I walked her through everything that had happened, from the initial demand for payment to the multiple court cases to the ongoing harassment. I showed her documentation for all of it. The article ran the following Sunday with the headline HOA War. Local resident fights back against unlawful claims and harassment. It was fair and well-researched, laying out the facts without sensationalizing them. The response was immediate and overwhelming. The newspaper received dozens of letters from other people in Asheville who had dealt with aggressive HOAs. Several other residents of Mountain View Estates reached out to me privately to express support and frustration with Patricia's leadership. More importantly, the HOA board apparently received a flood of complaints from members who were embarrassed by the publicity and concerned about the legal costs. Patricia's actions had cost the HOA tens of thousands of dollars in legal fees, fines, and damages, all paid from member dues. 3 weeks after the article ran, I received a certified letter from Mountain View Estates, HOA. It was signed by a man named Gerald Foster, who identified himself as the new board president. Dear Mr. Xavier, I want to begin by apologizing for the actions taken by our previous board president. The current board has reviewed your case thoroughly and agrees that the HOA has no legitimate claim to your property or to Clearwater Drive. We are directing our attorney to withdraw from any pending litigation and to work with your counsel to resolve all outstanding issues. Additionally, the board has removed Patricia Harrington from her position as president due to her handling of this matter. We hope to rebuild a positive relationship with all residents in our community, including those on adjacent properties. I called Derek. I think we won. I'd say so. Let me reach out to their attorney and work out a settlement agreement. We want to make sure they formally acknowledge your property rights and agree to stay away permanently. The settlement took about 3 weeks to finalize. The HOA formally acknowledged that I owned Clearwater Drive and had no interest in or authority over my property. They agreed to pay an additional $5,000 to settle the harassment lawsuit. They agreed to place a formal acknowledgement in their records that my property was not part of the HOA and never had been. And they agreed to prohibit any HOA member or representative from entering my property or contacting me for any reason without my explicit permission. In exchange, I agreed to drop all pending litigation and not to pursue any further claims related to the past harassment. I also agreed to allow HOA members to continue accessing the hiking trails via my road, provided they did so respectfully and without damaging the property. The agreement was signed in early December, 8 months after that first letter had arrived in my mailbox, but the story wasn't quite over. In January, I received a call from Officer Martinez. "Brandon, I thought you'd want to know. We've arrested Patricia Harrington." "For what?" "She's been embezzling from the HOA. Apparently, she'd been using association funds for personal expenses for years. The new board hired a forensic accountant after they removed her, and they found about $80,000 in fraudulent charges. She was using HOA credit cards to pay for vacations, home renovations, even her car payment." I was stunned. "Does this have anything to do with our case?" "The DA thinks so. Their theory is that she went after you so aggressively partly as a distraction." While everyone was focused on the road dispute, nobody was looking closely at the finances. Plus, those legal fees and fines she racked up made it harder to spot the missing money in the overall budget. "That's insane. White-collar criminals often do insane things to cover their tracks. Anyway, she's been charged with embezzlement and fraud. She made bail, but she's probably going to prison. Patricia's trial took place in April. I didn't attend, but I followed the news coverage. The evidence was overwhelming. The forensic accountant testified about the fraudulent charges. Multiple HOA board members testified about Patricia's erratic behavior and resistance to financial oversight. Even the HOA's attorney testified that Patricia had insisted on pursuing the case against me, despite his advice that it was legally baseless. The prosecution argued that Patricia had become increasingly desperate as her embezzlement scheme risked exposure, and that going after me served both to distract the board and to demonstrate her authority. If she could force me to pay thousands of dollars for a bogus claim, it reinforced her power and made board members less likely to question her decisions. The jury convicted her on 12 counts of embezzlement and fraud. The judge sentenced her to 4 years in prison and ordered her to pay full restitution to the HOA. I felt a strange mix of vindication and sadness when I heard the sentence. Yes, Patricia had made my life miserable for months, but 4 years in prison was serious. Then again, she had stolen $80,000 from her neighbors and used HOA business as a weapon against anyone who challenged her authority. Life slowly returned to normal after that. The new HOA board was professional and respectful. They sent me a formal apology letter along with a small gift basket, which was a nice gesture, even though it wasn't necessary. Several Mountain View Estates residents introduced themselves when they were hiking past my property, and most of them were friendly and embarrassed about what had happened. I continued working from home, enjoying the peace and beauty of my mountain property. The Mustang restoration project progressed nicely. I even started dating a woman named Michelle Turner, who I met at a coffee shop in Asheville. When I told her about my HOA battle on our third date, she laughed and said she had specifically chosen to rent rather than buy because she didn't want to deal with HOA drama. "You've got an HOA horror story and you don't even live in an HOA," she said. "That takes talent." By summer, the whole ordeal felt like a bad dream. I had my property, my road was maintained the way I wanted it, and I didn't have to deal with any association telling me what I could or couldn't do with my own land. Derek called me in July with news that the HOA had paid the final settlement check and all court orders had been satisfied. "You're officially done with legal proceedings. How does it feel?" "Like I can finally exhale," I said. "Thanks for everything, Derek. I couldn't have won this without you." "You had right on your side. That helps. Plus, Judge Morrison is a stickler for property rights. Patricia picked the wrong property owner and the wrong judge. Looking back on the whole experience, I learned several important lessons. First, always verify that a property isn't part of an HOA before buying and get it in writing from multiple sources. Second, document everything when you're in a dispute. Those security cameras and saved letters were crucial to my case. Third, don't be afraid to stand up for your rights, even when it's expensive and stressful. If I had paid that first $3,000 bill just to avoid conflict, Patricia would have kept demanding money, and I would have been funding her embezzlement. I also developed a deeper appreciation for clear property rights and the legal system that protects them. Yes, the process was slow and frustrating, but ultimately the courts got it right. Judge Morrison saw through the HOA's baseless claims and held them accountable for violating her orders. One afternoon in August, I was sitting on my porch with Michelle, looking out at the mountains and listening to the birds when a car pulled up to the entrance of my road. An older couple got out and started taking pictures of the scenery. Michelle noticed me tense up. "You okay?" "Yeah, I said, forcing myself to relax. "Just tourists. They're not here to serve me with papers or claim they own my road." She squeezed my hand. "That's all over now, I know, but it's going to take a while before I stop looking over my shoulder." "That's understandable." "Hey, you want to drive into town and get dinner? I heard about a new barbecue place." "Sounds perfect." As we drove down Clearwater Drive, my private road that I had fought so hard to protect, I felt a sense of peace that had been missing for almost a year. The asphalt was smooth under my tires, maintained exactly how I wanted it. The trees formed a green canopy overhead. And most importantly, nobody was going to send me a bill or tell me how to take care of my own property. The barbecue place was excellent, by the way. Michelle and I sat outside on their patio, eating pulled pork and talking about everything except HOAs. We planned a hiking trip for the following weekend and debated whether to catch a movie or go to a concert. Normal life. Peaceful life. The kind of life I had moved to the mountains to enjoy in the first place. Later that week, I got an email from Gerald Foster, the new HOA president. He wanted me to know that the board had implemented new financial controls to prevent future embezzlement, including quarterly audits and a requirement that 2 board members approve any expense over $500. He also said they had updated their records to clearly mark properties that were not part of the association, so future board members wouldn't make the same mistake Patricia had. "We're trying to learn from this experience and be better neighbors," he wrote. "Thank you for your patience as we worked through these issues." I appreciated the message. It showed that the new leadership understood what had gone wrong and was taking steps to fix it. I wrote back saying I appreciated their professionalism and hoped we could have a good relationship moving forward. Michelle moved in with me in October. She was working remotely too as a graphic designer, so we set up 2 home offices and spent our days working in comfortable silence, taking breaks to have lunch together or walk through the woods. "This place is magical," she said one afternoon as we hiked through the forest behind my house. "I can see why you fought so hard for it." "It's not just the place," I said. "It's the principle. If I'd let them push me around, they would have kept doing it. Patricia would have found more things to charge me for, more ways to assert control. It never would have ended." "You're probably right." Still, 8 months of legal battles sounds exhausting. It was. But you know what? I'd do it again. Some things are worth fighting for. We reached a clearing with a view of the surrounding mountains, autumn colors painting the hillsides in shades of red and gold. Michelle took pictures while I just stood there taking it in, grateful for this place and this moment and the simple freedom to enjoy my own property without someone trying to claim authority over it. The anniversary of that first letter arrived in early November. A year had passed since Patricia had sent me that demand for $3,000 in street maintenance fees for my own private road. A year of legal battles, harassment, court hearings, and stress. But also a year of learning, growing, and ultimately winning. I marked the occasion by having some friends over for a bonfire in my backyard. Derek drove up from Charlotte with his wife. Rebecca, my real estate agent, came with her husband. Officer Martinez stopped by off-duty with his girlfriend. And of course Michelle was there, helping me set up chairs and roast marshmallows. "Here's to property rights," Derek said, raising his beer bottle in a toast. "And to clients who are willing to stand up for them." "Here's to Brandon not backing down from bullies," Rebecca added. "And here's to never, ever living in an HOA," Michelle said, which got a laugh from everyone. We sat around the fire telling stories and enjoying the cool November evening. At one point, Derek mentioned that he'd started getting calls from other people dealing with aggressive HOAs, all of whom had read about my case in the newspaper. "You're becoming famous in the anti-HOA community," he joked. "People are citing your case as precedent." "I didn't set out to be anyone's test case," I said. "I just wanted to be left alone on my own property." "Well, you've helped a lot of people understand their rights," Rebecca said. "That newspaper article has been shared all over social media. I've had clients specifically ask to see it before buying properties." As the evening wound down and people started heading home, Michelle and I stayed by the fire, watching the embers glow in the darkness. "You ever think about what would have happened if you just paid that first bill?" she asked. "Sometimes. I think Patricia would have kept coming back for more. She was embezzling money, so she probably would have kept inventing fees to charge me. I might have ended up paying tens of thousands of dollars before I finally got fed up enough to fight back. Or you might have eventually sold the property just to get away from the harassment. Maybe, but I'm glad I stood my ground. This place means too much to me." "To us," Michelle corrected with a smile. "To us," I agreed. The following spring, I was contacted by a law professor at the University of North Carolina, who was writing a paper about HOA overreach and property rights. She wanted to interview me about my case as an example of how HOAs sometimes exceed their legal authority. "Your case is particularly interesting because the HOA was claiming authority over property that clearly wasn't part of their association," she explained during our phone call. "It shows how HOAs can become so focused on control that they lose sight of basic legal principles." I agreed to the interview, and we spent about 2 hours discussing the details of my case. She was particularly interested in how Judge Morrison had handled the contempt hearing and what that said about judicial oversight of HOA actions. The paper was published several months later in a law review journal. I couldn't understand half of the legal terminology, but Derek said it was an important contribution to the literature on HOA governance and property rights. "You're going to be cited in law schools," he said. "How does that feel?" "Weird," I admitted. "But if it helps other people understand their rights, I guess that's a good thing." Life continued to be peaceful and uneventful, which was exactly what I wanted. I worked on my projects, spent time with Michelle, and enjoyed my property without anyone trying to claim authority over it. The hiking trails near my property remained popular, and I occasionally chatted with friendly Mountain View Estates residents who passed by. One day in early summer, I was checking my mail when a car pulled up with an older woman at the wheel. She rolled down her window and waved at me. "Excuse me, are you Brandon Xavier?" I approached cautiously, still a bit wary after everything that had happened. "Yes, that's me." "I'm a leaner from Mountain View Estates. I just wanted to thank you." "Thank me for what?" "For standing up to Patricia. She was terrible as HOA president, but nobody wanted to challenge her because she was so vindictive. After what happened with you, the board finally had the courage to remove her and investigate her behavior. If you hadn't fought back, we might never have discovered the embezzlement." I didn't quite know what to say. "I was just protecting my property." "I know, but you did all of us a favor too." "The HOA is so much better now. Gerald actually listens to people and follows the rules. We haven't had a single lawsuit since Patricia left. I'm glad things improved. Anyway, I just wanted you to know that a lot of us appreciate what you did, even though you're not technically part of our association. You're a good neighbor." After she drove away, I stood there feeling oddly emotional. I hadn't thought about my fight with the HOA as benefiting anyone except myself, but Alina was right. By holding Patricia accountable, I had indirectly helped the entire Mountain View Estates community get better leadership. Michelle found me still standing by the mailbox a few minutes later. "You okay?" I told her about Alina's visit. I guess sometimes standing up for yourself helps other people too. Of course it does. Bullies don't stop with just one victim. You probably weren't the only person Patricia was harassing, just the only one who fought back publicly. That night, I did some research on HOA reform movements. I discovered that there were actually quite a few organizations working to curb HOA abuses and protect homeowner rights. Some states had passed laws limiting what HOAs could do, requiring more transparency in their operations, or making it easier for homeowners to challenge unfair rules. I even found online forums full of HOA horror stories that made my experience seem relatively mild. People who had been fined thousands of dollars for minor violations, or who had lost their homes to foreclosure over unpaid HOA fees, or who had been taken to court for painting their house the wrong shade of approved beige. Reading those stories made me grateful for Judge Morrison and the North Carolina legal system. Yes, my case had been stressful and expensive, but at least I'd had access to a fair court that protected my property rights. Not everyone was so lucky. In August, Derek called with news that made me laugh. Remember Patricia's attorney, Richard Thornton, the guy who kept arguing they had a claim to my road even though they obviously didn't? That's him. He's been disbarred. Seriously. Well, suspended for 2 years, which is basically the same thing. Turns out he knew Patricia was embezzling and didn't report it. He also apparently billed the HOA for work he never did. The state bar came down hard on him. Wow. So the HOA had a crooked president and a crooked lawyer. Birds of a feather. Anyway, I thought you'd appreciate the irony. The guy who threatened you with legal action is now facing his own legal consequences. I don't take any pleasure in other people's misfortune, I said, but I can't say I'm sorry to hear it either. As autumn arrived again, marking nearly 2 years since that first threatening letter, I reflected on how much had changed. My property was secure, my relationship with Michelle was strong, and I had become an unexpected advocate for homeowner rights. I still occasionally got calls from journalists or lawyers wanting to discuss my case, and I was always happy to share my story if it might help others. But mostly, I just enjoyed living my life without HOA drama. I fixed up the Mustang and took it to a car show in Charlotte, where it won a ribbon for Best Restoration. Michelle and I adopted a dog, a rescue mutt named Cooper who loved running through the woods behind our house. We planted a garden and learned to can vegetables. We hosted Thanksgiving dinner for our friends and families. Normal, peaceful life. The kind of life that shouldn't require a legal battle to achieve, but sometimes does. One afternoon in December, as Michelle and I were decorating the house for Christmas, she turned to me with a serious expression. "I've been thinking about something." "What's that?" "Would you ever consider buying a house that was in an HOA?" I paused with a string of lights in my hands. "Why do you ask?" "Just curious. After everything you went through, I wondered if you'd be completely opposed to it." I thought about it for a moment. I don't think all HOAs are bad. Some of them are reasonable and well run, but I'd be a lot more careful now. I'd read all the rules before buying. I'd talk to current residents. I'd make sure the board was transparent about their finances. And at the first sign of someone like Patricia, I'd run in the opposite direction. Michelle smiled. "Good answer. For the record, I like this place exactly how it is. No HOA, no rules about what color we can paint the shutters, no demands for fees we don't owe. Same here. This place is perfect." We finished decorating and stood back to admire our work. The tree looked beautiful with its lights and ornaments, and the windows glowed with candles. Outside, snow was starting to fall, dusting the trees and the road with white. My road. My private road. That I owned, maintained, and controlled without any HOA telling me otherwise. It had been a long, frustrating fight to protect that right, but standing there in my house with Michelle and Cooper, looking out at the snowy landscape, I knew it had been worth every moment of stress and every dollar of legal fees. Sometimes you have to fight for what's yours. Sometimes you have to stand up to people who think they have authority over you when they don't. Sometimes you have to be willing to go to court and let a judge sort out the truth. And sometimes you win. Not just for yourself, but for everyone who comes after you. Everyone who might face the same kind of bullying and overreach. As I settled onto the couch with Michelle to watch a Christmas movie, I felt a deep sense of contentment. This was my home, on my property, with my road leading to my door. Nobody could take that away from me. Patricia had tried and failed and gone to prison for her crimes. The HOA had learned a hard lesson about respecting property rights and choosing better leaders. And I had learned that standing up for yourself, even when it's difficult and expensive, is always the right choice. The snow continued to fall outside, blanketing everything in white. Tomorrow I would probably need to plow my road, using my own equipment that I kept in my own garage, on my own schedule at my own expense, exactly as I preferred. And nobody from any HOA was going to send me a bill for it, because this was my road and always had been and always would be.